hospital on a hospital bill, it deals with those that just simply will not pay. If you're below 125% of the poverty level, it doesn't touch you. And if you are making $5 a month payments, it doesn't touch you. So what it does is allow hospital authority, only hospital authority type hospitals to petition the Department of Community Health to look at hospital bills that they turn in and vet those, and if they determine that it is indeed a hospital bill that somebody owes and they just simply won't pay, then it gets sent on to Department of Revenue to, you can call it garnish or intercept or whatever, some or all of the tax return to pay that bill.
Chairman Martin.
Thank you, Mr. Chairman, and to Chairman McCall or Chairman Powell, does this, I mean, at some point, if a private hospital's trying to do this or a private party's doing this before the Department of Revenue can do that, they have to go through a due process type thing, and it seems like we've skipped that step here. Or, I mean, going before the community, the Board of Community Health is not like a legal due process to get a judgment to get somebody to get garnished. Is that also in there, Chairman McCall? You just...
I'm looking for the line, but I don't know which. I got so many scribblings here. There is a section in here that Community Health Act has one, along with being the clearinghouse. But if you look on line 165, it also gives a person a way to contest a decision of Community Health.
I guess my question is this a faster way to get garnished than you could get from a private party? If you got a judgment.
If you look on page 2, there's a whole laundry list of things that already do this. And it's just adding hospital authorities to that list, basically. And I would say that my original bill was 1.5 lines, and thanks to council and Chairman Powell's hard work on this thing, along with all the hospital people, this is what wound up. And it's a cleaner bill.
To address your question specifically, when this bill first came before the committee last year,
Yes, sir.
there were two concerns that we had. Number one, we wanted to make sure that there was a clearinghouse rather than 45 hospital authorities or 100 hospital authorities, each petitioning the Department of Revenue. So one issue was to find a clearinghouse, which we put in as Department of Community Health. The other was the issue of the liquidated nature of the debt, because we certainly did not want to say, and we all know how debts from hospitals or medical providers, that because of the complicated system in which we live, don't necessarily indicate the true cost of the service. And so rather than requiring that the hospital file suit and get judgments in all of these cases, we were trying to find a mechanism where whether it was the Medicaid rate or the Blue Cross Blue Shield negotiated rate or the Medicare rate. And what we wound up settling on was, because we found out that every hospital is required to have a policy dealing with financially distressed persons in dealing with those debts, which are usually somewhere in the neighborhood of 50% or less of the outstanding debt. And we said that no matter how much the hospital bill is for, that they could not claim under this system any more than what they would get under that applicable financial assistance policy. And so that was the way that this bill is drawn, to negate the effect of having the hospital go to the court system in order to collect these debts. If they did, they would be going after a higher amount usually. But the other thing is that there is a mechanism in here for a patient to appeal if they do not agree that they're subject to this procedure, or that they disagree with the amount of the debt, that they can appeal to a process through the Department of Community Health. And that's just a policy decision that this committee will have to make as to whether they want to give that expedited service or not.
Thank you.
I have a couple other questions. What?
It is, only, make sure they understand it is only for public county-owned type hospitals
Right.
created under the Authority Act.
Right. Representative Bentley.
Thank you, Mr. Chairman. And this may be a question for for Mr. James. Is it my understanding that the Hospital Association feel this legislation will help them generate additional revenue to help keep their doors open?
Mr. Chairman, if I may. I wouldn't call it generating additional revenue. I would
Okay.
say help them limit their bad debt. I mean, hospitals do $1.7 billion in uncompensated care each year. If we can limit that, especially for these, it's probably only 20 to 22 hospitals that this would apply to around the state, all in rural communities. Anything we can do to help them limit the amount of bad debt is crucial to keeping them open. Yes, ma'am.
Leader Trone. Not you. Who is 17? All right, any other questions? What's the pleasure of the committee? A motion do pass and a second. Any discussion? All in favor say aye. Any opposed? All right, chairman's in doubt. We'll ask for a show of hands. All in favor, raise your hand. And all opposed? 7-4, it passes on the rules.
Thank you, sir.
Yes,
Thank
sir.
y'all.
Next on the agenda is House Bill 373. Chairman Knight, where are you? Like a number?
19, Mr. Chairman.
Okay.
Mr. Chairman, 373 is some updates to the CUVA portion of the bill. We fixing a couple of problems such as mandatory surveying and recording those surveying, and also deals with documentation to prove evidence of the CUVAs. We're also looking at making it parity with the other appeals, other parts of the property code regarding attorney fees if it gets up to Superior Court and there's losses for attorney fees. This bill is just simply trying to make the process more fair and transparent for the folks who are applying for CUVA.
Are there questions? Hearing none, what's the pleasure of the committee? There's a motion and a second do pass. Any discussion? All in favor say aye. Any opposed? Passes to rules. House Bill 374. Chairman Knight.
Thank you. Mr. Chairman, there's another bill with dealing with the property assessment process and particularly the appeals. This bill is a fairness measure that provides the taxpayer protection. The bill provides taxpayers with more communication between the tax assessor and the taxpayer. It provides for some specific deadlines and some flexibility for agreed upon exceptions. It provides for the taxpayer remedy that is not provided, that if it is not provided timely due to the process through the appeals hearing currently, the law has no such remedy other than the courts. And this is a very badly needed process in which our property tax owners, both residential and commercial and industry, are quite frankly not getting their rights up under the Georgia Taxpayer Bill of Rights. This seeks to clarify the language and the process of the appeals.
Are there questions? What's the pleasure of the committee? There's a motion to pass and a second. Any discussion? All in favor say aye. Aye. All opposed? Passes on the rules. While we've got your light on, Chairman Knight, why don't you tell us about House Bill 888? And this completes your
No
quota
more.
for the session.
One more. 888, one more, Mr. Chairman. And again, these are important measures to Georgia and our economy. Everyone knows Georgia is the #1 place to do business. As such, the manufacturing in this state continues to increase and be a part of the growth of the state. 888 simply seeks to make sure that we're updating and looking at the way in which we're looking at the Freeport exemption. There's level 1 and level 2. The changes in these bills give some definition and some certainty as to the particular form that must be sent in order to constitute a complete application to the tax assessors. And what's happening now is, or what we're doing is we're prescribing a summary as prescribed by the department. So the commissioner will actually put down what is needed. Currently, it's just schedules, and this allows for the tax assessors to basically say, hey, we didn't get enough information or whatever, we're going to disallow your application. There are also other, and that's also on level 1 and 2 Freeport. We also put in some language regarding clerical errors shall not disqualify, a properly filed report. We're also looking at additional definitions and changing the definition to better reflect what the manufacturing process in Georgia is currently doing. And we believe this is going to continue to make Georgia the best place to do business in the nation and also attract more manufacturers to Georgia.
There are questions. Chairman Martin.
Mr. Chairman, to Chairman Knight, I'm with you on this. I think this week, when we talked about last week, I just want to not hold up the proposition or at this late measure the committee, but my concern last time was the definition of completed application. I was afraid the department would do that. I know you've done a great job in for filing properly. The scrivener's errors would not be construed as filing improperly, but could anybody play with a date? Are you comfortable that leaving a date out couldn't be construed as not a completed application?
Well, that's what we added that language specifically on line 49. Any clerical error, including but not limited to a typographical error, scrivener's error, or any unintentional immaterial error or omission. Okay, so I think we've done the best that we can to put in some common sense language that says to the tax assessors, if it's an immaterial error, that shouldn't disqualify this application.
And I'm not going to belabor the point, but you specifically on line 51, you say that should not be construed as failure to file properly.
Mm-hmm.
It doesn't speak to or failure to be a complete application. We can let it go, and if it's not a problem, it's not a problem. I know what the gentleman's trying to do. I support it, and just want to make sure we don't leave a hole in it.
And they will take advantage of one if they find it.
That's what I'm afraid of, Mr. Chairman. Yes, sir.
And certainly, as the bill moves through the process, Chairman Knight can perfect it further if he would like to. Any other questions? What's the pleasure of the committee?
Move to pass.
There's a motion and a second. Quit being so timid. There's a motion and a second. Do pass. Is there any other discussion? All in favor say aye.
Aye.
Any opposed? Passes on the rules. All right, we're now off the night agenda and back to the regular agenda. House Bill 696. Representative Kelly.
Thank you, Mr. Chairman. Members of the committee, I come before you today with House Bill 696, working off of LC number 430923S, which is a bill aimed to attract data centers to our state and to our communities. As we've heard extensive testimony in committee, the presence of data centers in our state will help us expand our connectivity to rural broadband and also be a tool used by our economic developers to help attract new business to our state, which I know is the goal of everyone on this committee. I want to just walk through some changes that were made in the subcommittee at the request of the chairman, and that dealt with making sure that the $250 million threshold that we've set forth in this bill is followed through. And so first, if you look on line 23, this will require a $20 million bond for any high technology data center to post. And then as we continue along it on lines 28, it begins to talk about some times when that bond would be forfeited, and that's if they fail to meet their data center minimum threshold by June 30th, 2028. And that's important because this bill does have a 10-year life cycle. We want to make sure that the results that we expect to get are also the results that we get. And if not, it's the I think, prudent measure for us to step back from the public policy if it's not working. It also talks about it to be forfeited if the data center files for bankruptcy, or if if the data center or their customers are issued any any abatement of property tax by a county or a municipality. And that's another important part to the bill, is that should there be any property tax abatement granted either to the data center or their clients on the equipment that's going inside the data center, that they would not be applicable for this sales tax exemption on the equipment that goes inside the co-location data center. The other item that we added that the chairman has asked for is on line 45, which gives the commissioner of revenue the ability to promulgate rules and regulations as she sees necessary. I will point out to the committee that through the drafting process, some language got changed inadvertently, and due to the timeline that this committee is working off of, we're not able to get another sub prepared or an amendment drafted, and that would take place on line 71, and this will be an amendment that I plan to have Chairman Powell offering rules, but I want to be upfront and honest with this committee as to what I will be asking to have changed. And on line 71, I would strike everything beginning after the word aggregate and replace with cost for the design, construction, and high technology data center equipment and high technology data center customer equipment deployed or used in or to support the high technology data center over a 10-year period commencing July 1st, 2018 and ending June 30th, 2028. And that sets the minimum investment threshold for $250 million before any equipment could receive the sales tax exemption as proposed in this bill. But I want to be clear that none of the costs incurred for the design or the construction, the costs associated with the design or any construction material cost would receive the sales tax exemption. It would only be the equipment that actually goes inside the data centers. Mr. Chairman, I'll be glad to answer any questions.
Are there questions?
Yes.
Representative Williams.
Mr. Chairman, to Representative Kelly, yesterday when we were in subcommittee, it was my understanding that there was an exemption on sales taxes on the materials used for the design, and
It's just on the equipment. They can
Just
use
on the
they can
equipment.
use the dollars that they invest on the design and the construction of the facility to help them reach the $250 million threshold, but none of that will receive the exemption, only the actual equipment that goes inside the facility.
just a follow-up question, was there any change in the language of that, or was that what that bill said the whole time?
That was the intent of the bill from the whole time.
Just a parliamentary point, Mr. Chairman, that was the point I was trying to make yesterday. It appeared to me in the language of that bill, that's all it was doing, so thank you for clarifying that.
Representative Bentley. Okay. Representative Parsons. Chairman Parsons.
Thank you, Chairman. I wanted to ask, I don't think I have the latest sub here, I don't think, but you'd mentioned you had included a part about having the Department of Revenue establish rules and regulations. I just wanted to ask you, what exactly does that mean? It seems like we're always giving these departments an awful lot of leeway. I'm just wondering what we're doing with this with DOR.
This would largely surround establishing and the certificate process and the application process for that, Mr. Chairman.
Okay, thank you.
Yeah, to further answer that, there's a provision in there that says that because they have 10 years to meet the threshold, that the department's supposed to periodically review their progress to make sure that they are continuing on track. And without some rulemaking process, it would be totally arbitrary and you might treat one data center different than another data center. So for uniformity purposes, it would be advisable to have regulations. Are there any other questions? Chairman Martin.
Mr. Kelly, just so I'm sure, if they're headed in this direction, they're on the slope to get to $250 million, they could open the center in phases. So they might not be to the 250 million, but they would be ready to put equipment in one side. They wouldn't pay, they would be exempt. This exemption would apply to that equipment as it went in.
That's correct.
And then there would be the forfeiture of the bond, or clawback, if you will, if they for somehow didn't reach that at a time, or the building, it didn't work out. They would forfeit the bond. And it looks to me like they could never have more money exempt than the bond would cover. That looks to me like that's the case, and that, I suspect, was your intent.
That's the intent.
Including, yeah, thank you.
Yeah, the bond's sort of an arbitrary amount, but it's based on 250 million times 7% plus some kind of interest for the fact that we have not interest and penalty on that money for a period of time.
Right.
Any other questions? What's the pleasure of the committee? There's a motion and a second to pass. Is there any other discussion? All in favor say aye.
Aye.
Any opposed? Moves on to rules. Representative Beskins, tell us about House Bill 820.
Thank you, Mr. Chairman and members of the committee. Today I have substitute to House Bill 820, that is LC 440807S. This bill provides a new homestead exemption from city and school system taxes for a municipality that has an independent school system. It applies for a municipality located in more than one county that levies a sales tax for a metropolitan area system of public transportation. The homestead exemption is in a floating amount to provide that the ad valorem tax on the homesteaded property can increase from one year to the next in an amount equal to the lesser of either the increase in the consumer price index or 3%. So that, Mr. Chairman, is the bill.
Are there questions? What's the pleasure of the committee? There's a motion, second. Discussion? All in favor say aye. Aye. Any opposed? Passes on the rules.
Thank you, Mr. Chairman.
House Bill 877, Chairman Nimmer.
Thank you, Mr. Chairman and members of the committee. Bring before you for your consideration House Bill 877 LC 345286. This bill came through your subcommittee, Mr. Chairman, and had a lot of good conversation over the couple of meetings we had. What this bill seeks to do is to get Georgia ahead of the curve from a 2009 congressional matter that was passed dealing with the FDA and modified risk tobacco. If this body moves forward with passing this bill and this General Assembly moves forward with passing it, as the FDA goes through the application process and weighs through all the pros and cons of the potential for modified risk tobacco, we would seek to lower the taxes on that if the risk is lower. Only if the FDA has approved these products. Now, this has been in effect from a congressional act since 2009, and so far there have been very limited products approved. We don't think there will be a windfall of tobacco products hitting the shelf with a modified risk label, but we want to be prepared if they are.
Are there questions? Chairman Stevens.
Thank you, Mr. Chairman. Just to be real clear, this is the first time ever in Georgia's history that we have reduced the excise tax on tobacco. Is that not true?
Yes, sir. I believe the gentleman knows of what he speaks. Mr. Chairman, I'm sorry.
Go ahead.
I just want to add to that, and Chairman Stevens and I have had good, friendly conversations about this, but I I would also remind the committee that this is also a modified risk product we're talking about, not a traditional tobacco product.
Any other questions? What number? All right.
Friendly question?
Probably not.
Maybe it'll stay off.
As a public health educator that has worked for a number of years, and the first tax I ever voted for as a freshman was to increase the tobacco tax after a number of years of not having an increase in the tobacco tax. I have a real problem with this, regardless of whether it being low risk or not. And we have one of the lowest tobacco taxes in the country, and we have had advocates come to us numerous times and say if we would increase the tobacco tax, we could use it to fund indigent health care. So although we're seatmates and we kind of go along with everything on timber, I can't go with you on this.
Okay, thank you. Very respectful, thank you.
Are there other questions? It's be proper time. All right, there's a motion and a second. Do pass. Any other discussion? All in favor say aye. Any opposed? We'll do a show of hands. All in favor, raise your hand. And all opposed? I count 9 to 4, 9 to 5. Okay, 9 to 5. Passes on the rules.
Thank you, Mr. Chairman, and thank you, members, for your consideration.
House Bill 944, Representative Peak. Chairman Epps, I think you're going to present for Representative Peak. Tell us about 944.
Thank you, Mr. Chairman and committee. I don't have a copy of the bill. I just was notified from Representative Peak. But 944 is basically Macon Bibb Commission is asking for a 1 penny OLOS, along with requesting creating a homestead exemption, which would put a freeze on property values with an annual increase not to exceed 2%. Because Macon Bibb is a consolidated government, it was necessary to go into general law so that a carve-out could be given for Macon Bibb that would affect only Macon Bibb County, as per advice given by Legislative Council.
All right, so are there two different pieces of legislation, one's here and one's somewhere else?
There's a general bill and then a local bill.
Okay, so the local bill has already moved through that
Right.
process. So tell us what this bill does.
This bill gives us a carve-out for Macon Bibb as one of the consolidated governments in the state of Georgia.
So is this a homestead provision and the other
Yes.
bill is the tax provision?
Tax provision.
Okay,
Correct.
so this is strictly just homestead?
Correct.
Okay. Are there any questions? What's the pleasure of the committee? There's a motion and a second. Any discussion? All in favor say aye. Any opposed? Passes on the rules.
Thank you. Thank you, committee members.
All right, the next two items on the agenda are mine, so I'm going to ask Vice Chairman Kelly if he will chair.
Thank you, Mr. Chairman. We'll now move on to House Resolution 1089. I'll let you present the resolution.
This is
1098.
This is a resolution that basically is an urging resolution to Congress requesting or urging them to pass the Federal Marketplace Fairness Act. As you all know, we've all been concerned as the out-of-state sales over the internet have grown about the ability of state and local governments to collect taxes on items that are purchased, even though they're brought into the state and subject to use tax already. And there's already a bill that has passed this House that deals with internet sales tax and passed out of Senate Finance about 2 weeks ago and should be on the Senate floor right after crossover day. And so hopefully that will give us a tool in our quiver, but quite frankly, until Congress acts, there can be no uniformity throughout the United States. It'll be a patchwork quilt of state actions, and it would be nice to have a uniform framework. So this is encouraging Congress to actually adopt the Federal Marketplace Fairness Act, even though we are going off on our own if they don't. So that's basically what the resolution is. I'll be happy to answer any questions.
Any questions for Chairman Powell? All right, we have a motion. Do we have a second? We have a motion and a second. Any discussion? All those in favor make it be known by saying aye. Aye. All opposed, like sign. Chairman Powell, your next bill, House Bill 811.
All right, House Bill 811 came through subcommittee. There have been 2 or 3 hearings on it. And basically what it does is allows the Department of Revenue to contract with outside vendors or providers to identify individuals or companies that may be shirking their responsibility to pay sales tax using computer analytics. And there have been a lot of enthusiasm in the subcommittee for this particular legislation, but there were some concerns about privacy, about confidentiality, about several other issues, all of which have been addressed in this recent version that deals with every one of the issues that have been raised. And so I'd be happy to answer any questions.
Any questions for Chairman Powell? Seeing none, what's the pleasure of the committee?
Move to pass.
We have a motion. We have a second. We have a motion and a second. Any discussion? Hearing none, all those in favor make me know by saying aye. Aye. All opposed, like sign. Congratulations, Mr. Chairman. You made it out of the full Ways and Means Committee.
I'm going to rules. I'm already bet Ways and Means. There's no other business to come before the meeting. We are adjourned.